Let's try to catch up while we still can. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so we've had 2 days worth of intensely insane new information in the Idaho 4 case when it comes to Bryan Kohberger being in court, and a bunch of information coming out when it comes to what Dylan's statements apparently was, the differences in whenever his phone actually went offline, off of network, compared to what's actually in the PCA. There's a lot that we're going to be going over in very small sections. What I wanted to do right now in this video is just do a short catch up on the documents that are not your normal, like, this is being sealed type document, because we do have some other information that has updated as of today, 129, in the case summary page, but we haven't gotten any new documents besides the one that I showed to my members in the members only live that I did on Monday, where Judge Hippler came out and said that he was going to have a transcript of the closed portion of the hearing that happened on Thursday, where we all sat there for 5.5 hours. I think it was like 5.5-ish hours, being told that it was closed, that they were going on break, that they were going to be back in a minute. And then finally we got about like 2 hours and 20 minutes ish or so of full court coverage. So that was an interesting day, but that was also where we got so much more information. So much more information. Now, and again, not just about Dylan and about the timing of the phone going off network, but about the car and all kind of stuff. Again, be watching for those shorter, sweet, to the point, subject-specific videos. They're going to be coming out one at a time until we get all of this covered. But according to this last document, Judge Hippler is going to allow both sides to, I guess, submit whichever portions they think should be redacted, and then the transcript is going to be given to the public. And before we get that very long, hopefully not too redacted transcript, and we start going over it here on the channel, I want to go through the couple of documents that we've missed, trying to catch up and keep up with everything that has happened in the hearings. We'll go over these, and then I'll show you guys the updated case summary. Now, I did post the very last page with the most recent updates in my community tab. So remember, if you have that notification bell set to all, you'll get notified of these community posts with this updated information way before I've gotten off work, had time to record, had time to edit, had time to download, had time to upload, had time to do the thumbnail, and had time to do all the rest of the things before it finally gets posted and is live for you to watch. So again, keep the notification bell set to all. Now, we went over this one where we had the defendant's first response to a request for discovery. I found that interesting. I had personally never seen that before, but it's apparently extremely common for both sides to ask for stuff. I just really thought that the state would be the one being like asked for things, the majority, like for the majority. But then again, we do have a possible Frank's motion coming up, which is something else that we are waiting on a response for. Now, at the end of the hearing on Friday, the new judge, Judge Hippler, did ask both sides to submit their next like 2 to 3 weeks worth of schedules so they could see if there was going to be a Frank's hearing, exactly when it was going to be scheduled. And honestly, with the way that he was asking questions and sort of the way that he was coming and going on both sides, it sounds like he might actually grant it. That would be insane. And I also don't know exactly how those work. We're going to have to look into that, because I don't know if that's something that we can see or not. Like, I don't know if that's something that he's going to allow to be public because of how sensitive that sort of information is. Because apparently the basis of a Frank's motion is literally to call out whenever law enforcement has done something illegal or incorrect, to call out by name or by specifics the officers, the people involved, the agencies. Like, it's very, like, it's serious. Like Jennings says, it's serious. It's serious. So I don't know if we're going to be allowed to see that. It would be interesting if we do, especially since Judge Hippler keeps making it very well known to the public and to the court that there's too much protective stuff going on here. And I really feel like the only reason why he even made so much of it on Thursday closed was because of the IGG information and it containing other people's names. And I really do feel, hopefully, that he's just trying to be super careful in that way to protect other people's identities that don't need to be involved in any of this. But I don't know. I don't know. Now, we also went over this one, and I was really still interested in who this is, because this is not Bryan Kohberger's defense team having somebody from out of state zoom in. Now, we did see Lisa Larkin and Bicca Barlow over on the defense side sitting behind Bryan Kohberger and his team during both days. And of course, we had Payne and Mowry on the other side. And we were told during court that Stephen Mercer, the other IGG guy that we've seen speak before, also came in to talk, but he's like a defense witness. He's not a state witness. So I'm really curious as to who this is. And I know that some people are thinking that maybe it's Othram. And I don't think that it would be Othram, because Othram apparently didn't find anything. So that would be more like a defense witness to prove that, like, the original sample that went over, these hella experts didn't find anything. So that being said, I don't know. I don't know who it could possibly have been. All I know is that Othram doesn't sound right to me. And they have a long list of expert witnesses that the defense is claiming there's no opinions, there's no analysis, there's nothing like that. But the only thing that I can really think of is it would have to be somebody that has to do with the IGG that the state brought in to explain something to the court. And just like we heard Judge Hippler state, he is expecting whatever the like mini lesson is on IGG and DNA or whatever, like whatever the actual presentation is going to be to teach the jury about what they're about to hear about. According to the way this is worded, he's not wanting it to just be in the disclosure that this person is going to be giving like a mini lesson on DNA. He wants the actual verbatim lesson, like the actual attachment of what's going to be shown and talked about to the jury. He wants that attached to it. So he wants to be able to see everything. But it's still kind of bothering me because I feel like he is helping the state. I really do feel like he's helping the state in this, because the state does not know how to argue. They're very, very not confident. And he had to lead them a lot when it came to these last two hearings, especially about what Dylan says about who and what she apparently saw, or what the who looked like that she apparently saw that night, why it's even in the PCA. And the only thing that she's originally talking about is for identification. And then the judge is like, and for timeline. And she just keeps on talking about identification because it's a general description. But she literally just blurted out 5 seconds before going on and on about nothing at this point that Dylan didn't recognize what she saw. And like I mentioned, even though she didn't recognize the person at the time, she would have recognized that facial structure. She would have recognized the eyebrows, the way they fit over his eyes, the way his eyes are shaped, his sockets, his cheekbones, the top portion of his nose. Like, something about his face would have stuck in her mind. And even if she would have just a little bit said, man, that could be, but no, for the state to be coming out here and being like, she didn't recognize, that's a big deal. And why people are like acting like that's not a big deal, I don't know. But Jennings basically stopped talking, and then the judge is like, and what about timeline? And she's like, oh yeah, timeline too. And that's how we heard about the text communications that we've all been talking about forever, okay, for freaking ever, finally being validated by the state. So I don't like the way he's leading. And again, and what we're going to be talking about here at the end, because of what's on the case summary page that's incoming, the state is getting like emboldened, I feel, with way too many chances to do things that they should have already done. And we'll get to more of that in a minute. Now, this is an order that was posted regarding the presentation of ICC evidence. Yeah, you notice how it's misspelt? It's the IGG evidence. But this gives us an explanation as to why the Franks hearing stuff was actually talked about. So this was written by Judge Hippler. As discussed with the parties at the January 21st, 2025 status conference, there was a significant evidentiary overlap between defendant's motion to suppress genetic information and defendant's motion for a Franks hearing insofar as it pertains to his proffer regarding law enforcement's use of IGG. Although the hearing set for January 23rd, 2025 is not intended as a Franks hearing, in the interest of time and efficiency, the court will permit the parties to present their evidence on the IGG issue as if it were a Franks hearing. By permitting such evidence, the court is not concluding or implying that defendant has satisfied the preliminary showing required by Franks on the IGG issue, nor is the court bound to consider the full extent of evidence if it ultimately concludes defendant's proffer insufficient to warrant a Franks hearing on the matter. This is simply intended as a time and resource saving measure, which is why at the end of court on Friday, he said, give me your next 3-week schedules, and if I want to do this, I'll let you know when. And again, it's crazy to me how somebody can be an out-of-state witness via Zoom. And this is a quadruple homicide, but I couldn't zoom in for my DV case for me and my kids' own safety. That is wild. But something else I would like to also point out here is that this is not a singular. This is not a singular. This is witnesses, out-of-state witnesses. And what do we know about Dylan and Bethany? Yeah. So there's a lot of people that are wondering if this is for Dylan and Bethany, because it says witnesses, and it's not just the one expert witness that we've seen a subpoena ducis tecum for, but we have seen more than one regular old schmegular subpoena like the one that I had. This very well could be Dylan and Bethany. I guess we'll find out. Now, see, this is the one that is for the out-of-state expert witness from the subpoena ducis tecum, and the name is null and void. But yeah, these are definitely two different things here. Now, again, today is January 29th. And even though we haven't had a new document since that last one about the transcript, the case summary page itself was updated today. And this is the portion that I ended up posting in my community tab. But there's a couple of other things in here too that we just haven't been able to see yet. Something I find interesting is that we have this sealing stipulation to allow out-of-state witness to testify via Zoom, and it's denied. I'm not really quite sure what this is, because if you go back to these, you don't see anything that says anything about anything being denied. Let's go back and check one more time, though, because I could be wrong, but let's take a look. I don't see any denials here when it comes to Zoom. Let's type in Zoom so that we can know what we're looking at. Let's go down to where we need to be in 2025. Let's see here. Keep going. Okay. Motion to seal stipulation to allow out-of-state witness to testify via Zoom. This is not a denial. This is interesting too, though. Like, this is crazy wording. Wherefore, the state respectfully prays that the court seal from public disclosure the stipulation to allow out-of-state witness to testify via Zoom, herein under those provisions. Defense counsel has advised that they have no objection. And that was submitted on January the 16th. Then we have this one that we just looked at that says witnesses on it. And again, I'll show you guys on the case summary page. So if you go all the way back to December 26, 2024, that's never we had the subpoena ducis tecum. Okay. Now let's go find the first of the actual normal regular schmegular subpoenas. The first one is right here on 1/3 of 25. And then I believe the other one was on 1/15, right here, subpoena issued. Those are not subpoenas ducis tecum. That's one subpoena ducis tecum and two regular schmeglers. So I say again, could it be Bethany and Dylan? Possibly. I don't know about the other one, though. All I know is that for it to be Othram and it be a state witness makes no sense to me. Now, we do have this one for this newly filed record. We have no clue what it is. Now, Ann Taylor mentioned something about a brand new police report in court, but that's all she said. Now we've suddenly got information about this brand new police report we've never seen before. That could be what this is. I don't know. Now, we also have a supplemental response for the penalty phase experts and a 20-second supplemental request for discovery, meaning we are this far in. We are 2 seconds away from hopefully a Frank's motion, and the defense is still requesting stuff that is absolutely wild. Now we have this motion to seal Exhibit U to defendant's 20-second supplemental request for discovery, and then a subject document motion to redact or seal the newly filed record for the 20-second supplemental request for discovery. Now, this is the one that made me want to put this in the community tab, because this bothers me, because like I've mentioned a couple times already, I feel like this judge is leading the state. I do. I feel like he's leading them because they're weak, and he knows they're weak. At this point, he has seen so much of this case, and now I feel like he is leading them to help them because they're weak as shit, okay? We have known from the beginning that the state is the one who has wanted the IGG removed from trial literally from day one. What have we been able to determine here on this channel, folks? that before Bryan Kohberger even was extradited back and touched back down in Idaho, that WSU and Don Daniels and everyone that she was talking to was trying to get the IGG suppressed before he was even extradited. When Don Daniels took her information to her court in order for Bryan's apartment and office at WSU to be searched, she specifically asked for them not to consider the IGG whenever they took this into consideration, and that they had to exclude it from the reasoning for why they would accept this as probable cause. Again, this was before Bryan even touched foot back in Idaho. They were trying to suppress the use of the IGG. Then what did we hear? What did we hear next? That the state planned on filing a motion of limine from day freaking one, basically, in order to exclude the IGG and not have it talked about in trial. And why have we talked about that so much? Because the IGG has been the biggest fight. The biggest fight. And what did Judge Hippler say in court, for those of you who are paying attention? That all of these things about his Fourth Amendment rights being violated and these policies all being broken, the evidence sure is pointing to that. The evidence is sure showing that, and that's coming out of Judge Hippler's face. Okay, go find it. All you got to do is go to the bottom of the description box on any of the things that we're streaming it live. Click on Show Transcript. Let it load. Control F. Type in a few keywords. Go find the spot yourself. Okay, Judge Hippler is admitting that all of these things are a problem and are very, very real. So, of course, the state has been wanting to exclude the IGG from day one. It's what's going to get their asses in trouble. But now that the defense team apparently has full written proof that his Fourth Amendment rights were violated and that policies were broken and that the laws did something illegal, now we're about to have this Frank's motion. Now we're about to be really popping off some information and seeing what happens here. And people have been throwing a holy cow toddler-sized fit because the defense is wanting to remove the IGG, not giving a holy hot damn that the state has been begging for it to be removed without actually filing the motion to do so since the very beginning. There's a reason why the judge also said that there's a lot of this stuff that didn't need to be public because some of these things might not even be evidence at trial. Evidence that doesn't exist, meaning stuff that will be excluded, suppressed, removed. That's where we are with the IGG. And that's also bullshit because it's one of the biggest problems, if not the biggest problem here. But it's also the only thing tying Bryan Kohberger to the scene. The only thing that has been verified in court, stated by the state that it is the single piece of evidence. What else does anybody with a brain need to know that there's a freaking problem here? But again, if you see the title of this document, what does that state? Stipulated motion to extend the deadline to file the motions in limine. Why does the state need more time to do something that they've already said that they were going to do for 2 years now? The judge should be like, no, bro, you've already done all of this stuff about the IGG. It's already been the biggest fight of this entire thing. It's going to the end. It's going to be the end game. Now, according to the scheduling order that was created after the change of venue, the motions of limine, including the 404B notices, which is the death penalty notice, is to be filed by the day before Valentine's Day, by February 13th. Okay. Why they need, again, more time. They have 2 weeks. Oh, they have 2 weeks right now. It is the 29th of January. They got 2 weeks before deadline. They have been threatening to file this motion of limine literally from day one. And they need an extension. They shouldn't need an extension. If the judge grants that extension, it's going to show more of his true colors. Because I already feel, again, like he is leading the state. So far in these hearings, these past two that have been hella ridiculous, I feel like he has been helping the state, leading the state in order to get them to answer things correctly for the record. And I don't appreciate it. I don't like it whatsoever. I do appreciate the fact that he is paying attention to what's happening and he's asking the right questions. But again, I don't like the way that he's leading the state to make themselves look relevant. The fact that he had to get the state to admit that putting that information in the PCA was more about the timeline than about Bryan's identification is stupid, because it was literally stated. And then she went on this whole rant after saying that Dylan didn't recognize Bryan in any way, shape, form, or fashion. And then she still needed to be led again into it being about the timeline. She's not good at what she does. But Santa Claus just sitting back there letting Jennings tank, which is wild to me too, because why are you not helping clean up this mess? Whatever. But that's it. Like I said, I wanted to try to get caught up on what we could get caught up on before we ended up getting bombarded again. Because once we get that transcript and once we have the opinion about the Franks motion, if it's going to happen, once we have the Franks motion, if it happens, like there's going to be a lot of stuff. Plus, we're really trying to get all of these new details that we heard about so many things. Like I said, Dylan, the car, all the things. We're trying to get all of that nailed down so that we don't have any discrepancies and we have the most accurate information that's out there. So again, let me know what you guys think. And do you guys think that they are going to end up allowing the state the extension on the motion of limine? I don't believe that they should get one. Like I said, they've been saying that they wanted to exclude it literally from day one. We've gone through what happened with Don Daniels, and now we have them asking for an extension when they still have 2 weeks. Like, I don't understand what you need more time for. If you've been wanting to do this since forever, shouldn't you already have your argument laid out for the reason why you want this to happen? I don't understand. Whatever. Let me know what you guys feel about this ridiculous stuff down in the comments, though. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.